process in making international law binding in the Philippines and resolution in case of conflicting interpretations. The governing principles. There are two pertinent principles that govern the process in making international law binding and valid in our jurisdiction. First is the principle of incorporation. Second is the principle of transformation. The doctrine of incorporation means that the rules of international law are a part of the law of the land, and no legislative action is required to make them applicable to a country. The Philippines follows his doctrine, because Section 2, Article 2 of the Constitution states that the Philippines adopt the generally accepted principles of international law as part of the law of the land. Section 2, Article 2 of the 1987 Constitution states that the Philippines renounces war as an instrument of national policy, adopts the generally accepted principles of international law as part of the law of the land, and adheres to the policy of peace, equality, justice, freedom, cooperation and amity with all nations. As cited by the Supreme Court, although the Philippines was not a signatory to the Hague and Geneva Conventions, international jurisprudence is automatically incorporated in Philippine law, thus making war crimes punishable in the Philippines. Lo Cheng vs. Archbishop of Manila, 81 Phil 601. Borowski vs. Commissioner of Immigration, G. Arno. L. 4362. Also, in other case where prolonged detention of a stateless alien pending deportation was deemed illegal, citing the Universal Declaration of Human Rights, which is incorporated in Philippine law. On the other hand, the doctrine of transformation requires that an international law principle be transformed into domestic law through a constitutional mechanism, such as local legislation. Pharmaceutical and Healthcare Association of the Philippines v. Duke, G. Arno. 173,034, October 9, 2007. The transformation theory is applied in the Philippines through treaty-making power of the President. Through this power, rules and principles embodied in a treaty in force would be transformed into Philippine law and shall become valid and effective upon the concurrence of 2/3 of all members of the Senate. Resolution in case of conflicting interpretations. A. On the domestic sphere, with the local court deciding. A.1. If the conflict is with the Constitution, uphold the Constitution. In Secretary of Justice v. Judge Landon, G. Arno. 139,465, January 18, 2000, it was held that in states where the Constitution is the highest law of the land, such as the Republic of the Philippines, both statutes and treaties may be invalidated if they conflict with the Constitution. A.2. If the conflict is with a statute. The doctrine of incorporation, as applied in most countries, decrees that rules of international law are given equal standing with, but are not superior to, national legislative enactments. A treaty may repeal a statute, and a statute may repeal a treaty. Thus, the principle of lex posterior derogat priori, that which comes last in time, will usually be upheld by the municipal tribunal. See also Chong vs. Hernandez, 101 Phil. 115, where it was held that the retail trade nationalization law prevails over the Treaty of Amity with China and the Universal Declaration of Human Rights. Because the law was passed in the exercise of the police power of the state, and police power cannot be bargained away through the medium of a treaty or a contract. B. On the international sphere, with an international tribunal deciding. International law is superior to municipal law because international law provides the standard by which to determine the legality of a state's conduct.